If affordability is going to be the rallying cry for both Republicans and Democrats going into the midterms, it makes zero sense for Trump and Republicans to be fighting for tariffs and shaking up the economy this close to elections. Opening up trade to expand supply is the only way to lower costs, and between the economic uncertainty and tax on imports, aka tariffs, Republicans are going to have a tough battle to fight in the optics of affordability. It's been a week since the Supreme Court rightfully dealt a major blow to Trump's tariff plan, and while I'm not generally in favor of tariffs and don't believe the president has unilateral authority to place whatever tariffs he wants whenever he wants, the decision has already and will likely continue to cause some chaos in the near future as the administration is scrambling to come up with new legal justifications for them and businesses will push to receive payments for lost revenue, which is one of the reasons Justice Brett Kavanaugh dissented against the majority opinion, but we'll get to the rulings and reactions shortly. First, what were the legal justifications that were struck down? The administration has used the International Emergency Economic Powers Act, or IEEPA, to impose tariffs since the beginning of his term. The IEEPA allows a president to regulate commerce in a national emergency, but Trump became the first president to use the act to impose tariffs, since taxes have to be approved through Congress, having the power of the purse. Tariffs are, in fact, just a tax, and there are some valid reasons to use tariffs, but in select cases, as I talked about in a previous video, specifically about tariffs. Blanket tariffs do nothing except raise consumer prices in exchange for an increase in government revenue that is not equal to the economic loss in spending. But anyway, the IEEPA historically had been used to impose sanctions on enemies or freeze their assets, not to impose tariffs. Now, the law does not specifically mention the word tariffs, so Trump's Justice Department argued that the IEEPA allowed tariffs by authorizing the president to regulate imports to address emergencies. However, the court majority seemed to rely on the major questions doctrine, which is the basic idea that the executive cannot regulate on issues of significant economic importance without clear explicit authorization from Congress, since again they have the power of the purse. Chief Justice Roberts specifically has in his opinion that when Congress delegates its tariff powers, it has done so in explicit terms and subject to strict limits, not the vague language included in the Emergency Economic Powers Act that the administration was using. Justice Gorsuch concurred, saying that whatever else might be said about Congress's work in the IEEPA, it did not clearly surrender to the president the sweeping tariff power he seeks to wield. The three more liberal justices, Kagan, Sotomayor, and Jackson, took a simple statutory interpretation, basically meaning that since the IEEPA does not specifically mention tariffs, and the executive authority to regulate importation doesn't include taxes, the law can't be used as the basis for tariffs. Now, Justice Gorsuch kind of called out this irony of the statutory interpretation of the more liberal justices in his opinion due to their support for the expansive language of other statutes the Biden administration used to use OSHA to impose a vaccine mandate on 84 million Americans, use the EPA to regulate energy distribution, regulate landlord-tenant relations nationwide during COVID-19, and cancel $430 billion in federal student loan debt. Just an interesting point on how they choose to interpret legal language differently between administrations. On the other side, the minority dissenters, Justices Kavanaugh, Thomas, and Alito, argue that the regulation of foreign commerce is entirely in the executive control. If the president has the ability to regulate foreign commerce, like import quotas or embargoes, then there's no reason to believe he doesn't have the authority to implement tariffs. And since Trump has declared national emergencies over economic imbalances, that opens up the IEEPA to justify the tariffs. But the other justices would argue that because quotas or embargoes don't involve money changing hands or government revenue, and simply limits what goods or how many can be imported, that doesn't expand into the power of the purse, which would have to be explicitly delegated by Congress. Kavanaugh does point out two other key issues. One is the problem of recourse. With these tariffs being struck down, the question becomes of whether the U.S. may be required to refund billions of dollars to importers who paid the IEEPA tariffs. The other question shifts to how much of the costs were transferred to consumers. Does the government refund all citizens who bought products from tariffed importers? The refund process is likely to be a mess. Now, a messy refund process is not a very good reason to keep the tariffs in place. I'd say it's more of a reason to not implement them in the first place unless you have bulletproof legal justification. Then this doesn't happen and the markets are not thrown into chaos. The other point Kavanaugh makes is how narrow the ruling is, saying that the decision might not substantially constrain a president's ability to order tariffs going forward. The ruling only reviews tariffs imposed on the basis of the IEEPA, so the space for Trump or future presidents to use other statutes remains fairly large. That being said, only about half of the tariffs imposed by the administration were justified under the IEEPA, so the other half are not affected by this decision and leave the administration other options to reimpose similar tariffs using other sections of the Trade Act of 1974, which Trump has already done in response. Tariffs on imports deemed a threat to national security fall under Section 232 and have been levied against Chinese steel and aluminum imports. And tariffs to combat unfair trade practices like intellectual property theft fall under Section 301, and that includes a lot of technology and industrial materials that have been largely tariffed since 2018. Sections that have been eyed by analysts and commentators as potential options for the administration to use are Sections 122, which empowers the president to address large and serious balance of payments deficits through import surcharges of up to 15%, import quotas, or a combination of the two, and Section 338, which authorizes the president to impose tariffs of up to 50% on imports from any country that, quote, discriminates against U.S. commerce as compared to other nations. Section 122 provides the fast and easy fix for the administration's roadblock, since the language basically authorizes tariffs against any nation we have a trade deficit with, and there's no judicial precedent clarifying its limits. But the catch for that one is that tariffs under the section have to expire after 150 days, unless Congress votes to extend them. This is what the administration is currently using for the immediate 10% tariff after the ruling, which may be raised to 15% in the near future. Customs and Border Protection sent a memo informing importers that the rate would be 10% at first, and that it would apply to every country for a period of 150 days, unless specifically exempt, and that took effect on Tuesday. Section 338 has such vague language that the president can tariff any nation that supposedly discriminates against the U.S. But what does that really mean? Does any trade balance infer discrimination? If another country has tariffs on our products, are they discriminating against us? There are a lot of questions to answer, and neither of these statutes have ever really been tested in court, which favors the administration's goals, but it also means that we could end up back in the same situation sometime down the line. Additionally, if Trump wants to add more products to the Section 301 tariffs for unfair trade practices, a formal investigation into the supposed unfair trade practices will have to take place first, lengthening the process and uncertainty. To me, all of this is exactly why presidents shouldn't be the sole arbiter of financial policy. I get that Trump is a true believer in tariffs, despite all of the economic theory pointing to major deadweight loss and price increases, but now we're experiencing round 2 of global uncertainty. And if there's one thing that markets and investors hate, it's uncertainty. Suppliers will opt to make deals with people they can rely on, which is why many countries are becoming friendlier with China. Something I feel like I've said in most of my videos about foreign policy lately. Obviously, that's not a good thing. The administration would be smart to actually justify their policies before implementing them, or just drop the tariffs and go for the free trade option. Especially since there are reports that Trump may roll back some tariffs to lower prices before the midterms. If affordability is going to be the rallying cry for both Republicans and Democrats going into the midterms, it makes zero sense for Trump and Republicans to be fighting for tariffs and shaking up the economy this close to elections. Opening up trade to expand supply is the only way to lower costs, and between the economic uncertainty and tax on imports, aka tariffs, Republicans are going to have a tough battle to fight in the optics of affordability. Thank you for watching. Let me know what you think about the Supreme Court ruling and the future of tariffs. If you enjoyed, don't forget to like and subscribe, and I'll see you in the next one.